The Fourth Amendment rules ICE must follow, and what happens when they don't, Immigration and Customs. Enforcement agent Jonathan Ross shot Renee Good 3 times through her windshield in South Minneapolis on January 7, 2026. She was a 37-year-old mother of 3, sitting in her Honda Pilot. Video shows. She steered away from Ross and appeared to be driving in the correct direction on a one-way street. Ross fired in under 1 second, keeping his phone in his left hand while drawing his weapon with his right. 17 days later, Alex Predia, 37-year-old ICU nurse at the Minneapolis Veterans Affairs Medical Center, was filming federal agents during another operation. Agents pepper sprayed him, pinned him to the ground, and fired 10 shots in 5 seconds. He was holding his phone in one hand and his glasses in the other. He had a legally owned firearm for which he held a valid permit, but witnesses testified he never brandished it. Agents discovered the weapon only after he was already subdued. Both were American citizens. Both shootings happened during Operation Metro Surge, which deployed over 3,000 federal agents to Minnesota starting in December 2025, the largest immigration operation in American history. Both deaths exposed something more troubling than the shootings themselves. ICE systematically broke constitutional rules protecting people from unreasonable searches and seizures. The Fourth Amendment protections that govern when law enforcement can enter your home, conduct searches, and use force weren't bent in Minneapolis. They appear to have been abandoned entirely. Fourth Amendment protections and judicial warrant requirements. The Fourth Amendment contains 54 words. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue. But upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. For your home specifically, the Supreme Court has been unusually protective. In Peyton v. New York, the court held that police cannot enter a home without a judge's permission to arrest someone, even for a felony, without first getting a warrant signed by a judge. This applies to ICE. Immigration agents have broad authority to question people they suspect of being in the country illegally. But that authority doesn't extend to forcing their way into homes. Any forced entry requires either a judicial warrant signed by an independent judge based on probable cause, or what courts call emergency situations, where waiting for a judge's permission would be dangerous or impractical. Courts have defined emergency exceptions to include hot pursuit of a fleeing suspect, preventing imminent destruction of evidence, or providing emergency assistance. What it doesn't include: situations police deliberately create to justify entry, speculative concerns that something bad might happen if they wait. The May 2025 ICE memo, reversing warrant policy. For decades, ICE operated under a clear policy. ICE officials, not judges, signed administrative warrants, and these couldn't authorize forced entry into homes. A 2007 letter from DHS Secretary Michael Chertoff to Senator Christopher Dodd stated this plainly. A warrant of removal is administrative in nature, does not grant the same authority to enter dwellings as a judicially approved search or arrest warrant. On May 12, 2025, Acting ICE Director Todd Lyons issued an internal memo reversing that position. The memo authorized ICE agents to use administrative warrants, internal ICE documents, as the sole basis for forcibly entering homes. Agents could knock, identify themselves, and if residents refused entry, use necessary and reasonable force to enter based solely on the administrative warrant. ICE agents could now authorize their own home entries, instead of asking judges. Instead of proving to a judge they had good reason, agents could now make that determination internally. Professor Orrin Kerr, a Fourth Amendment expert at the University of Arizona, analyzed the policy and concluded the DHS position is likely wrong because Supreme Court rulings say a judge must approve warrants. Multiple federal judges have expressed similar concerns. Some lower courts have ruled that ICE violated the Fourth Amendment by forcibly entering homes without judicial warrants when no emergency existed. The Department of Homeland Security's initial characterization of Renee Good's shooting claims she weaponized her vehicle and violently, willfully, and viciously ran over the ICE agent. DHS Secretary Kristi Noem stated Good attacked agents and attempted to run them over and ram them with her vehicle. Video shows Good steered away from the agent. She appeared to be driving in the correct direction of traffic on a one-way street. Ross drew his weapon and fired 3 shots in under 1 second while keeping his phone in his left hand. When journalist Jake Tapper challenged Noam on this during a televised interview, directly stating that's not what happened, "We all saw what happened," Noam responded. "It absolutely is what happened." Despite video evidence showing the opposite, federal officials initially claimed Preddy wanted to do maximum damage and massacre law enforcement. President Trump posted an image of Preddy's gun on social media and called him a gunman. Remedies available for Fourth Amendment violations by federal agents remain inadequate. Lawsuits against them are hard to win. Prosecutors decide whether to investigate, and they're choosing not to. Judges can't punish ICE if ICE leadership decides following orders gets in the way. What the events in Minneapolis revealed is that the Constitution only protects you if courts, Congress, and prosecutors enforce it. The Fourth Amendment's words haven't changed, but the ways to enforce it, court orders, funding decisions, prosecutions, lawsuits have all failed when an agency chooses operations over following the law. 2 American citizens are dead. ICE has detained thousands of immigrants and separated them from families. ICE has systematically ignored court orders preventing deportations. Entire communities have lived in fear and experienced disruption and harm. ICE is still using the May 2025 memo to force its way into homes. The Justice Department refuses to investigate whether federal agents broke the law. Congress can't force ICE to follow the law. Federal judges keep issuing orders, and ICE keeps ignoring them.